Thank you for coming on, taking some time out of your morning to come on to our webinar. I am a paralegal. My background lies in real estate, and I've been, over the last 2 years, actually, I've been developing these seminars, and I've been presenting them live at real estate offices throughout the GTA. This one in particular, unfortunately, I'm not able to present it live in person. It's my pleasure to present it to you guys over Zoom. So this series is actually called Best Legal Practices in Owning and Operating Rental Property. This is around COVID-19 and what it means for realtors, landlords, investors, and tenants. For those of you who haven't done so already, if you are on social media, if you can head over there, follow us on Facebook and Instagram. I always put updates pertaining to landlord and tenant matters, interesting 1-minute video clips, and I post more of our interesting facts about tenancy issues on our social media. You can also check us out on our website at stonegate-legal-services.ca, or give us a call anytime if you have a landlord and tenancy matter that you are facing. So just a brief introduction about myself. I entered the real estate realm back in 2004, 2005. I got my real estate license, and throughout obtaining my license, I attracted landlord and investor clients who, purchased small to medium-sized apartment buildings, but they were either out of town or out of province, and they didn't want to deal with the day-to-day operations. So their tenants would call me for everything. So rent collections, maintenance and repairs, complaints, they would call me for everything under the stars. And then what I would do is I would actually head over to the board to evict the tenants on matters pertaining to rent collections, illegal activities, maintenance. And more often than not, I found that the adjudicators or the judges would dismiss my hearings because I wasn't a licensed paralegal or lawyer. So I went back to school and I obtained my paralegal license, and my real estate business has shifted such that I only operate my paralegal firm full time. So I do have a real estate background. 95% of our business comes from realtors like yourselves because we specialize in this particular area of law. So just a little disclaimer before we start the presentation. Everything we discuss, all the questions that we do a Q&A in the end, everything is for information only, and nothing is to be taken as legal advice. If you do have a matter, or if you do have a question that you want to talk to me about privately, feel free to give me a call at the end of the presentation. Okay, so for those of you who've never dealt with a paralegal before, I'll outline the differences between a paralegal and a lawyer, because I am not a lawyer. Like lawyers, paralegals are licensed by the Law Society of Ontario. Like realtors, paralegals and lawyers have to abide by rules of conduct. We have to maintain and are now required to carry errors and omissions insurance. We have to do our continuing education credits. So there's a lot of similarities between paralegals and lawyers. There's only a couple of differences. So let's talk about the fee structures. Paralegals, of course, charge lower fees, and lawyers charge higher fees. And the reason for that is because lawyers have far more extensive education than paralegals do. Not to say that lawyers have far more extensive knowledge or training in certain areas of law. That's not the case, because actually paralegals usually have more knowledge about, the lower courts, being, tribunals, licensing appeal tribunal, landlord and tenant board, a small claims court, whereas lawyers practice law in the higher courts, such as the family law, higher criminal law. That's basically the major two differences between a paralegal and a lawyer. So I just have a couple of preliminary slides before we get our feet wet with COVID-19. The reason I want to go through these two preliminary slides with you is because we're going to be referring back to them throughout the presentation. So I want you to get familiar with the terms that I'm using. Let's talk about the Residential Tenancies Act, or the RTA. Prior to being called the Residential Tenancies Act, the law that governed the realm of tenancies was called the Tenant Protection Act. And it did exactly that. It protected the tenants. Over time, that legislation got amended, and now it's called the Residential Tenancies Act. The RTA came into effect in January of 2007. It creates a rental housing system that protects tenants, helps landlords, and promotes investment in Ontario's rental housing market. This piece of legislation alone affects about 1.4 million renters in all of Ontario. So we're going to keep going, referring back to the RTA. Let's talk about the Landlord and Tenant Board. Okay, so for those of you who have never dealt with the Landlord and Tenant Board, consider yourselves extremely lucky. And I'll tell you why. The Landlord and Tenant Board is among the top 3 boards that I would say it's actually number 1 or 2, it's a tie, that it's the most chaotic and disorganized board out there. And the reason for that is because you'll have 2 showing times. Once you receive a notice of hearing, your hearing times are either at 9:30 in the morning or 1:30 in the afternoon. However, if you do have that time slot at 9:30, plan to be there the whole day, because there's no structure on when your matter is going to be called. So if your matter is called on the date of your hearing, great. But if it's not, if the adjudicator doesn't get to it, then it'll be adjourned to another date. That's why it's so unorganized. So the Landlord and Tenant Board, or the LTB, resolves disputes between landlords and tenants, and either party can pay the filing fee and apply to the board for a hearing date. And for those of you who've actually attended a hearing at the Landlord and Tenant Board, you would have noticed that the board is set up similar to a court-like setting. So there's the adjudicator or the judge in the front, and then there's the applicant and respondent, so the landlord or tenant or landlord, and everybody else waits in the back. Disputes at the board can be worked out in one of 2 ways or in both ways. So let's talk about mediation. That's, the first way of that disputes can be worked out. I'm a big fan of mediation. I think mediation is a great idea. And the reason for that is because the parties have an influence on the outcome of the matter. So at mediation, an LTB mediator, board certified mediator helps the landlord and tenant reach an agreement that they're both satisfied with. So when you go to your hearing date, you'll have to agree to go to mediation. So you sign up for it. Then you wait for your name to be called and your file number to be called. You'll probably sit in a room that's about 10 by 10, around a round table. And that mediator will go through, asking you questions on how to better resolve your matter, or how to come up to a resolution that both parties are satisfied with. And then they'll draft a mediated order. So of course, not everyone will be happy with what's discussed at mediation. If you can't come up with an agreement in mediation that you're both happy with, then you have no choice. You have to go back to the hearing room and you have to wait for the adjudicator to call your matter. Now, the second form of ways that a dispute can be worked out is through adjudication. An adjudicator, or the deciding member, is basically the judge who hears, when you go there, you'll probably notice they have stacks and stacks of files. They probably have 60 or 70 files that they have to listen to and decide on in a matter of about an hour and a half to 2 hours. So the adjudicator doesn't care about the little details, the minor details, your evidence, who said what. They don't care about all of that. They listen to one side, they listen to the other side, and they apply the law, and that's it. They'll send out their decision cold turkey in the mail. That's why mediation is such a great idea. It's such a great way to work out your problem, because you'll actually end up having an influence or some sort of control on the outcome of the matter. Okay, so now that we've talked a little bit about how disputes can be worked out and the Residential Tenancies Act, let's talk about concerns surrounding COVID-19. So our firm has been flooded with calls over the past, I would say, 3 weeks regarding, from realtors and landlords and investors alike, regarding what's been going on and how their business has been affected by these uncertain times. These are the top 6 concerns that I've been trying to calm a few nerves on. So we're going to discuss them throughout the presentation. Okay, so the first I want to say, before we get into getting our feet wet with rents, from this slide on, I may sound a little insensitive. Okay, so please forgive me if I sound a little insensitive. And the reason for that is because the law has no feeling, there's no emotion attached to it. It's either black or it's white, and that's it. So let's talk about the rents. Can tenants stop paying rent during the COVID-19 pandemic? Okay, so the answer to this question is absolutely not. No. The Residential Tenancies Act, so the RTA, says that rent is due and payable on or before the first of the month, or whenever you agree that it's due. Rent is considered late if it's not paid by the day that it's due. Meaning, if rent is due April 1st and the landlord hasn't received it on April 2nd, rent is considered late. If a tenant does not pay rent by the date that it's due, the landlord has the right to give the tenant an N4, notice to terminate tenancy for non-payment of rent, after the day after the rent is due. So for those of you who've never heard about an N4, what is an N4? An N4, notice to terminate tenancy for non-payment of rent, it basically gives a tenant 2 options, okay? So it gives a tenant an option to pay all the arrears in full, and that way the notice is void and the tenant doesn't have to move out, or they have to move out of the rental unit within 14 days. After 14 days, if the tenant does not pay in full, and if they are still in possession of the rental unit, the landlord has the right to apply to the Landlord and Tenant Board for a hearing date. Okay, so absolutely no way does a tenant have the right to withhold rent because of what's going on with COVID-19. There are tenants and landlords alike that have been affected by what's been going on, and we're going to talk about relief options throughout the presentation. But the answer to this question, no, the rent cannot be held back. So this is what an N4 looks like. The top here is the first page. The bottom there is the second page. It's where the calculations are. I can't stress this enough. Realtors cannot fill out or serve this notice or any landlord and tenant board notice, okay? Guys, I know that we take on leases as a favor to our clients. I've done it in the past myself where, I do a lease as a favor because there's really not any money in it by the time you kick up to the broker. However, by filling out, putting pen to paper and serving these notice on behalf of your landlord, you're not doing them any justice. And I'll tell you why. Prior to the COVID-19, it took on average about 5 months to get a hearing date. Okay, so 5 months. Imagine a tenant stops paying. 5 months later, you get a hearing date. After March 16, because March 16 is the date when the Landlord and Tenant Board has closed their doors and they're not taking on any in-person hearings with evictions attached to them. And this notice, the N4 notice, has an eviction attached to it if it's not carried through by the tenant. After the board has closed the door, we're assuming that once the doors reopen, it's not going to take 5 months to get a hearing date anymore. It's now going to take anywhere from 9 months to 12 months, okay? And a realtor filling out these notices, if there's a mistake in the name, if you forget the postal code, or if you forget the unit number, or if you miscalculate the figures, or you miscalculate the days, you're going to risk having this notice dismissed on the day of your hearing. So if it's going to take 9 months to get in front of the board, once it's disclosed to the board who filled out and served this notice, the adjudicator will dismiss your application, and your landlord, your client, is going to have to incur another 9 months because they're going to have to sort of restart the process over again to come back to the board. So this is why it's so important. Realtors, please do not fill out or serve these notices. So Another big question I've been asked is, can the last month's rent be used to cover the month that the tenant cannot pay? So the answer to this question again is a hard, cold no. Okay, so the landlord can collect a rent deposit from a new tenant on or before a start of a new tenancy. Okay, so prior to the acceptance of a lease, a landlord can collect a rent deposit. The deposit cannot be for more than 1 month's rent, and the deposit cannot be used for anything else except for the last month's rent. Okay, I'll tell you why. If the landlord decides to eat up that deposit for the month of April, what can happen is that if you have a tenant that's very savvy and they know how to work around the law, they can actually skip out on 1 or 2 months closer to the end of the term of their tenancy. That's why the landlord, it's very important that the last month's rent not be used to cover anything except for the last month's rent. Okay, so let's talk about service of notices. Can the landlord still serve notices? So the notices I've listed here, the N4, N5, N6, N8, N12, N13, these are all notices served from the landlord to the tenant that has an eviction attached to it if there's a breach of the notice. And I'll tell you what that means. That means that, you know, if for the N4, let's use the N4 for an example. The N4, which says that the tenant has to pay the arrears in 14 days or vacate the unit. There's no way that notice can be enforced unless it goes to the board and an eviction is obtained. An eviction order is obtained. Although the board is closed right now, the landlord still has the right to serve any notice in order to commence a paper trail. You have to keep in mind, it's inevitable that the board will reopen. The landlord will eventually get a hearing date, whether it's 5 months, 6 months, 9 months, 12 months. Those tenants who, you know, are holding back rent are usually the ones that have a high possibility of being evicted. We're going to talk about tenants who are withholding rent throughout the presentation as well. Let's talk about what is going on with in-person hearings at the board. So after March 16th, those landlords who have received hearing dates, for whatever date after March 16th, those hearing dates are going to be rescheduled for a later date. These are the hearing dates that are going to be rescheduled because they have an eviction attached to them. There are alternative options such as a written or telephone hearing that the board will consider. However, usually those hearings that are written or are considered for written and telephone hearings are hearings that don't have an eviction attached to them, such as a tenant's rights application or a maintenance or repair application. These are applications that can be worked out through mediation. So if you have a hearing date after March 16th, we're prepared to wait until, I'm not even going to say a date, probably months down the road before it even gets rescheduled. Okay, so let's talk about mortgage deferrals. I'm not a mortgage broker, so if you have in-depth questions about mortgage deferrals, please contact your bank representative or your mortgage broker. But the questions that I've been receiving, or my office has been receiving, from landlords or realtors, is that tenants are saying to them that, you know, your mortgage is going to be deferred, so why do we have to pay the rent? Well, I just want to define a deferral. What is a deferral? A deferral is to postpone to a future date. A deferral is not a forgiveness of a mortgage payment. That's why rent still has to be paid, because there's ongoing expenses incurred on that property. In order to approve for a mortgage deferral, there's a qualification process. And right now, the criteria is still a little unclear. I actually had a client who had called in to one of the major banks on Friday, and she had spent about 6 hours on hold trying to speak to a representative. So if you're still inquiring about a mortgage deferral, be prepared to be on hold for an extensive amount of time. Also, new mortgages do not qualify for a deferral. In order for you to be qualified for a deferral, you still have to go through a credit check. You have to fill out a credit application. So there's still a process that has to be, followed. CMHC will actually support lenders in allowing deferral of mortgage payments for up to 6 months. This is great. If you go on your major bank's website, you'll probably see a mortgage deferral calculator, and depending on which bank you have, who's the lender of your property, there's a cap on how much can be deferred up to 6 months, and I believe it's $5,000. So if you input the maximum amount that you want to defer, and if you look at how much it's going to cost you in interest, deferrals can often result in double payments when they become due. So you may want to actually calculate if it's even worth it to do a deferral. Okay, for those of you who belong to social media sites such as Facebook, landlord and tenant groups, you've probably seen these ads floating all over social media. This is the Keep Your Rent movement, April 1st. This movement has been organized by the Parkdale community, which is a low-income tenant community located in downtown Toronto. They've all come together, and what they're doing is they're encouraging other tenants to hold back the rent, because what they're saying is that the landlord doesn't need your rent, but the tenants need to eat. So they've put together this movement, and there are thousands of landlords that have been affected. Our office has been flooded with calls since April 1st regarding this particular movement. These are the ads that are floating around social media. So if you belong to tenant and landlord groups, you're probably seeing them. They're encouraging other tenants to hold back their rent. And the reason for that is because, you have those tenants who have actually been genuinely affected by COVID-19. So they've either suffered an illness, they've suffered a temporary or permanent job loss. Then you have tenants who, the bottom of the barrel tenants who think that we're going to jump on this window of opportunity because we want to hold back the rent and either spend it on whatever, food, alcohol, medication, whatever the case is. Those are the tenants who, will eventually get evicted because the rent has still got to be paid. So whether they pay it right now or pay it in the future, if they don't pay it, if they have no means of paying back the arrears, then there's a possibility that they will get evicted. Those tenants who have genuinely suffered either temporary or permanent job loss or an illness or taking care of a family member who is being affected by COVID-19, those are the tenants who have genuinely been affected and who feel defeated. They feel that they don't have any relief options. Okay, so before the landlord jumps the gun and before, everybody starts offering free months or rent discounts, there are relief options available for tenants. So what I'd be more than happy to do, if you guys type in your emails in the chat section, I'd be more than happy to send you a PDF copy of this presentation, or I'll send a copy to Aaron and Tina, and they can send it off to you guys as well, so you can refer back to it. So let's talk a little bit about relief options for tenants. So these are the top 3 relief options. I'll go through all of them. We'll go through the pros and cons of each one, and then I'll make a recommendation of what I think is the most effective one. So let's talk about a payment plan. There's 2 types of payment plans, okay? So there's a payment plan that's backed by the Landlord and Tenant Board, and those are the payment plans usually that are backed with an eviction clause, which means if they're not followed through 1 day late or $1 short, the landlord can pursue an eviction. So there's a payment plan that's backed by the board, and then there's a payment plan right now, because the board is closed, that everybody is considering. This is the payment plan that's put together by the landlord and tenant. The issue with the payment plan that's put together by the landlord and tenant is that, the landlord and tenant, they don't often provide clarity of what is expected from the payment plan. And usually those landlords that are offering a rent discount or a free month, if your payment plans are not clear and if they're not properly worded, down the line, when the dust settles with what's going on with COVID-19 and the board reopens, the landlord can actually find that they have permanently lowered lawful monthly rent. And that's what we want to stay away from, okay? Politicians are asking landlords to give free months or rent discounts, but are not protecting them. So although a payment plan is a great option, the question you have to ask yourself as a landlord or a realtor or an investor is that what happens if the tenant doesn't follow through with this payment plan that we put together? How can I enforce it? So now let's talk about a rent bank. I know that majority of people, so 99% of people have never heard of what a rent bank is. The rent bank is a great option, great relief option. And it is exactly what it's called. It's a bank that tenants can turn to, which provides limited interest-free or very low interest loans to seniors, individuals, basically anyone facing an eviction for rental arrears, or anyone facing a difficulty in paying their rent. The rent bank is great because it offers a maximum loan of 2 months rent. So tenants who have bruised credit, who filed for bankruptcy, who have consolidation, who are not working, who receive some sort of assistance, but their assistance is not enough to cover the rent, they can turn to the rent bank for assistance. The rent bank also provides a rent deposit loan, which is the first and last month's rent, in order for a tenant to move from where they are to a more affordable or stable housing. This is fantastic. Another major benefit of the rent bank is that there is no need to come up with a payment plan. There is no need for a landlord to pursue the legal route to evict a tenant. The rent bank is great because the landlord gets paid instantly, and the tenant can repay the rent bank back as per a payment plan without interest or with very little interest. Okay, that's why the rent bank is so great. So I put the number to the Toronto rent bank, if you can see it up there, because that's the more popular one. However, if the rental property is located in York region or Peel region or Halton, all you can do, the best thing to do is Google York region rent bank or Halton rent bank or Durham rent bank, and the information will come up and your tenant can contact them. Their turnaround time is about 5 to 7 business days. So if your tenant didn't pay April 1st, the best thing to do, as always, is on the 2nd to serve the N4 and let them know that the relief option exists for a rent bank, that they can pursue the rent bank. However, as a landlord, you also want to cover yourself and provide them with the necessary N4 document in order that they can't pay. So number 3, the third relief option is credit card option for rent payments. So I'm going to show you here. This is my AirPod case, okay? But this is not the product I'm going to promote. I'm not promoting this product at all. This is what it looks like. If you Google Square, the product looks like this. It's a square itself. It's got a port like that. And that port hooks up to your iPhone port like this. And once they connect, it links to your the banking app on your phone. So the landlord will have the option to accept rent payments via credit card by swiping the credit card, tapping the credit card, manually inputting the credit card and expiry number. This product is great. The best thing about this is that the landlord gets paid instantly, okay? Although the downfall of the credit card option is that, it is high interest to the tenant. However, it keeps them in the home. Okay, so out of the 3 payment plan options, I highly recommend the rent bank. The rent bank is great for anyone that's facing an eviction for rental arrears. Okay, so we want to make sure and communicate with our tenants that there are relief options available to them. The objective is not to evict the tenant. The objective is actually to keep the tenant in the home. However, we at the same time, we understand that landlords have ongoing expenses that they have to pay for on the property. So rent has to be paid. It cannot be held back.